Hello friends, welcome back to my YouTube channel, that is Discourse on Law and Politics. So in today's video we are going to cover 100 MCQs which are important for the UP Judiciary examination as well. So for UP Judiciary these are questions very important and it is like a revision. So if you have prepared yourself for the examination, then you can go with this revision here, so that you can check that how much you have prepared, about what kind of preparation you are having for your examination for the judiciary prelims. So let's start. So we are going to cover 100 questions. So one by one we will take the questions from the Indian Contract Act. All these questions which we are going to cover here, they are majorly from the Bayer Acts. So it will help you to see that how much you have done preparation for the judiciary, particularly for this subject of the Indian Contract Act with the Bayer Act. Okay, let's start. So the first question: an agreement enforceable at law is, the options which are given here: enforceable acceptance, accepted offer, approved promise, or contract. So which one of the right answer? You know that answer, just give your answer to the comment box immediately. I am waiting for your response. It is a very simple question. All the students of the law who are no student of the law, they must know this answer here. So just see which is the right answer. Yes, the answer is contract. Now coming to the next question: every promise and every set of promise forming the consideration for each other is an agreement, contract, offer, acceptance. So which is the right answer here? Just give your answer to the comment box. It is very easy question. All these questions which we have read till now, they are from section 2 of the Indian Contract Act. Yes, just give me answer. Yes, they are going to be called as a agreement. So every set of promise or every promise forming the consideration for each other, they are being called as a agreement. Next question: promises which form the consideration on the part of consideration for each other are called reciprocal promise, cross offers, conditional promise. So it is a promise which is considered for the each other. So obviously the answer must be the reciprocal promise. Now an agreement not enforceable by law is stated to be void under which section? Section 2D, Section 2E, Section 2F, Section 2G. These questions are very much going to come in examinations from the Bayer Act. So just give your answer here. Waiting for your answer to the comment box. Yes, this is being called as under section 2G. Coming to the next question: void agreement signifies agreement illegal in nature, agreement not enforceable by law, agreement violating legal procedure, agreement against policy. Give your answer immediately through the comment box. These are questions very important for the UP prelims as well as for other competitive examinations of the judiciary of other states. Yes, the answer is agreement not enforceable by law. Now offer as defined under section 2A is, the options which are given here: communication from one person to another, suggestion by one person to another, willingness to do or abstain from doing an act in order to obtain the assent of other thereto, or the third last option, that is the none of the above. So give your answer. So what is the definition of offer which is in the section 2A? Yes, just give your answer. Very easy. Yes, it is willingness to do or abstain from doing an act or in order to obtain the assent of other thereto. Going to the next question: under section 2B of the Indian Contract Act, if the person to whom the proposal is made signifies his assent, the proposal is said to have been. So if a person to whom the proposal is made and that person signifies his assent, the proposal is going to be said whether it would be accepted, agreed, or it is going to be provisionally agreed or tentatively accepted. So what is the answer? Just give your answer immediately. Yes, the right answer is here. That is the accepted. Okay. So going to the next question, question number 8. A proposal when accepted, it becomes promise under section 2b, agreement under section 2e, contract under section 2h, or none of the above. So give your answer immediately. I am waiting for your answers. Yes, once a proposal when accepted, it becomes. So give your answer to the comment box. I am waiting for your response here, my dear friends. Yes, the answer is A, promise under section 2b. When at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstain from doing, or promises to do or to abstain from doing something, such act or abstinence or promise under section 2 is being called. This is very important question. You all know the answers. So just give the answer immediately. The options which are given here: reciprocal promise, consideration for the promise, counter offer, acceptance. So what is the answer? Yes, the answer is under section 2, the section 2d, the definition which has been given, the definition which is given, it is the of the consideration. So you can see here, this is the answer. Moving to the next question, promises which form the consideration or part thereof for each other under section 2f are called. So now under section 2f, the promises which form the consideration or part thereof for each other under section 2f, what kind of the definition is given here under Indian Contract Act? So let's see the options which are given here: acceptance for different proposals, agreements, reciprocal promises, or the consideration. So give your answer to the chat or to the comments here. I am waiting for your answer here. So they are being called as a reciprocal promises. Okay. Moving to the next question. Every promise or set of promise forming the consideration for each other under section 2e is called. Okay. The options which are given here: reciprocal promise, B, contract, C, agreement, and D, none of the above. So give your answer immediately through the comment box. I am waiting for your response here. Every promise or set of promise forming the consideration for each other under section 2e is called. What kind of the provisions they are being called under section 2e? Just give your answer here. Waiting for your response. Yes, very easy a question. Yes, this is the agreement. Moving to the next question. That is the question here. An agreement enforceable by law at the instance of one party or not of other party under section 2i is called. An agreement enforceable by law at the instance of one party and not of other party under section 2i is called. Options which are given here: a valid contract, an illegal contract, a void contract, or the fourth one, a voidable contract. So give your answer here. Waiting for your response, my dear friends. Which is the right answer? This is being called as a voidable. Okay. Because voidable contracts is going to enforceable at the instance of one party, not of the other party. So therefore, in that case, it would be a case of the voidable contract here. Moving to the next question, which is here, which is correct. We have to see here: proposal plus acceptance becomes a promise. Promise plus consideration becomes the agreement. Agreement plus enforceability becomes a contract. And D, all of the above. So give your answer. Waiting for your response. So you all know that, my friend, that whenever there is a proposal plus acceptance, it is going to promise. When promise plus consideration, then of course it is going to agreement. Agreement plus enforceability, that means enforceable by law, it becomes the contract. So therefore, all the statements which are given here, they are correct. Moving to the next questions, question number 14 here. Let's see. So you can see the question here. In a valid contract, what comes first? In a valid contract, what comes first? Whether the enforceability, acceptance, promise, or proposal. So among four these options in a valid contract, what comes first? So just give your answer here. When you are going to make a contract, for a valid contract, when you are going to do have a valid contract, which step will come first? Okay, so just see here options and give your answer through the comment box or through the chat box. Yes, the answer is here, which you all can see. That is the proposal. Firstly, you all need to have a proposal, and then in that case you can have this one. Okay, you can go for the valid contract. Now coming to the next question, under section 2C, promiser is, who is a promiser? Person who makes the proposal, person who accepts the proposal, person who makes the promise, person to whom the proposal is made. So what is the definition of the promiser under section 2C? So just give your answer. The questions are very easy, and these types of the questions are going to come in the UP prelims. Okay, and also in some other states also. So who is a person who is being called a promiser? You all know that. The answer here, yes, the answer is a person who makes the proposal. Moving to the next question, under section 2C, promisee is, who is a promisee? Persons who makes the proposal, person who accepts the proposal, person who makes the promise, person to whom proposal is made. So there are four options. So under section 2C of the Indian Contract Act, who is a promisee? So just give your answer to the comment box. Looking for your answers here. Bataiye fatafat, which is the right answer here? Yes, the answer is person who accept the proposal here. Okay. Moving to the next question, goods displayed in a shop with a price tag, whether it would be an offer, invitation to offer, counter offer, or none of the above. So just give your answer. Again, this is a question which is from the Indian Contract Act. So just give your answer here. Which is the right answer? Yes, this is the invitation to offer. So whenever any goods are displayed in a shop with a price tag, it would be a case of the invitation to offer. Now, what is a tender? Tender is the options which are given here: an offer, an invitation to offer, a counter offer, or a promise. So just give me the answer here. What is a tender? Waiting for your response here. Yes, the answer is here: an invitation to offer. Moving to the next question, question number 19. Communication of a proposal is complete. When a communication of proposal would be complete, when it is put in the course of transmission, when it comes to the knowledge of the person to whom it is made, when the proposal is communicated to the person to whom it is made, or all of the above. So when the communication of the proposal is going to complete, just give your answer. Again, these are the questions which are coming from the very basic provisions of the Indian Contract Act, and you all have read. So now just give your answer immediately. I know you all know the answer correct here, so don't hesitate to give your comments here. Yes, the answer is when it comes to the knowledge of the person to whom it is made. Okay. Moving to the next question, communication of acceptance is complete as against the proposer. When the communication of acceptance is complete as against the proposer, now the options which are given here: when it comes to knowledge of the proposer, when it is put in the course of the transmission to him so as to be out of power of the acceptor, when the acceptance is communicated to the proposer, and last, all of the above. So now communication of acceptance is complete as against the proposer. When it is going to happen? So just give your answer here. Now you all know the answer here. The answer is this, the answer B. When it is put in the course of transmission to him so as to be out of power of the acceptor. So once he has put his communication of acceptance in the course of transmission, and now it is out of his power of the acceptor, then in that case it would be said that the communication of acceptance is complete as against the proposer. Moving to the next question, question number 21. communication of acceptance is complete as against the acceptor when it comes to knowledge of the proposer, when it is put in the course of transmission, and the third is when it is communicated to the acceptance that the acceptance has reached the proposer, when the proposer convey the acceptance to the acceptor. So now give your answers here immediately. The question is here. I am going to again to the question number 21. When communication of acceptance is complete as against the acceptor. Yes, when it comes to the knowledge of the proposer. Okay. So this is the question which you can find here. Moving to the next question. Question number 22. Revocation of offer by letter or telegram. Revocation of offer by telegram or letter case can be completed when it is dispatched, when it is received, when it dispatched, when it is received by the offeree, when it reaches the offeree, or D, both A and C. So just give your answer when a revocation of offer by letter or telegram can be complete. Just give your answer to the comment box. I am waiting for your response here. Yes, the answer is when it is dispatched. Good. Acceptance to be valid must be absolute, be unqualified, both be absolute and unqualified, and be conditional. So acceptance to be a valid must be absolute, be unqualified, both be absolute and unqualified, or be conditional. So just give me your answer here. I know you all know the answer here. So yes, the answer is both. The acceptance must be absolute and unqualified. Moving to the next question. A contract with or by a minor is. So when you are doing a contract with or by a minor, what would be the nature of that contract? Whether it would be a valid contract or void contract, voidable contract, voidable at the option of either party. So just give your answer here. You all have heard this important case also, Mohini Das. Yes, the answer is this one, void contract. Moving to the next question. A contract with cases to be enforceable by law become void when it ceases to be enforceable. When it ceases to be enforceable, the option second is before it ceases to be enforceable, no such condition necessary, and the last one is none of the above. So just give your answer here. A contract which ceases to be enforceable by law become void. When it is going to be void? Just give an answer to comment box. All these questions are very preliminary in nature, but they are very important for the competitive examinations. To these questions, the commission they want to know whether do you know about the basics of the contract or not. So just give your answer immediately through the chat box, through the comments. Please just give the answer. Yes, the answer is here, when it ceases to be enforceable. Moving to the next here. An acceptance can be revoked at any time before the communication of acceptance is complete as against the promisee, after its acceptance comes to the knowledge of the promisee, both A and B, and the last option, that is D, neither A nor B. So what is the right answer here? Just give me answer. An acceptance can be revoked when? Yes, it can be revoked at any time before the communication of acceptance is complete as against the promisee. Moving to the next question. A proposal stands revoked. When a proposal stands revoked? By communication of notice of revocation by the proposer, by failure of acceptance to fulfill a condition precedent, by death or insanity of proposer to the knowledge of acceptor, and D, all of the above. A proposal stands revoked by which options? Just give your answer. All these questions are very preliminary in nature. Yes, a proposal stands revoked in all these three cases. So when a notice of revocation has been communicated, failure of acceptor to fulfill a condition, and in case of death or insanity of proposer, then in that case, in all these cases, the proposal stands revoked. So the answer is all of the above. Moving to the next question, a proposal can be accepted. When a proposal can be accepted? By a notice of acceptance, by performance of conditions of proposal, by acceptance of communication consideration for a reciprocal promise, and D, all of the above. So just give your answer here. A proposal can be accepted when? I am waiting your answer to the comment box. Please participate and see how much you have prepared for the prelims here. Yes, the answer is here, all of the above. So proposal can be accepted in all these three cases. Okay. Moving to the next question here. Question number 29. Enforceable agreements are the one made by free consent. Parties to the contract are competent to enter into an agreement having lawful consideration and lawful object, and D, all of the above. So just give your answer here immediately. What are the important things which makes any agreement as enforceable? Just look into those principles. You will be able to answer. Yes, just give your answer to comment box. Waiting for your response here. So if you see this, all these are the corrects, and the answer last is all of the above. Coming to the next question, competency to contract relates to age of the parties, soundness of mind of the parties, both age and soundness of mind, intelligence of the parties. So competency to contract relates to what kind of the things? So just give your answer here. So just give your answer here. Competency to contract relates to. So just give answer immediately. So a person is competent when he is above the age of 18 and he is having soundness of mind. So that means both conditions are required for competency to contract. Moving to the next question. Which one of the following is correct? We have to see which one of the following is correct. Past consideration is no consideration. Consideration can be past, present or future. The third is consideration can only be present. And the fourth one is consideration can only be present and future. So just give your answer immediately here. Which one is the correct answer here? I am looking for your response. Yes, the right answer is here. The consideration can be past, present or future. Past consideration is valid in England only, India only, both in England and India, neither in England nor in India. So just give your answer here. Waiting for your response. Yes, it is in both in England and India. Moving to the next question, question number 33. An agreement not to raise the plea of limitation is whether it is a valid one and binding, void, voidable, illegal. So give your answer. An agreement not to raise the plea of limitation, whether it would be a valid, void or illegal. Waiting for your response. Give your answer through the chat box. Yes, waiting. Yes, you are right. The answer is void, because you can't make an agreement where you can put a restrictions on someone that you can't raise the plea of limitation. Okay. A letter of acceptance sent by post is lost in transit. एक लेटर भेजा गया और रास्ते में वो खो गया. There is a concluded contract as the letter of acceptance is put in the course of transmission. There is no concluded contract as the acceptance has not come to the knowledge of proposer. There is no concluded contract as the acceptance has not been communicated to the proposer, or all of the above. So which is the right answer here? So as per the law of the contract is concluded the moment you put it in the course of transmission. So that is how you can find that letter of acceptance is concluded once you have put into the course of transmission. Coming to the next question, when the consent to the contract is caused by coercion, the contract under section 19 is whether it would be a valid one, voidable, void, illegal. So just give your answer. Under section 19, whether it would be through the coercion, if you are going to have a contract, whether it would be a valid, or it would be. Moving to the next question, question number 36. A son's forged B's name to a promissory notes. B, under threat of prosecuting A's sons, obtains A's sons forged B's name to promissory notes. B, under threat of prosecuting A's sons obtains a bond from A for the amount of forged note. If B sues on this bond, the court. So now the options which are here: has no jurisdiction to this case, must not set aside the bond, may set aside the bond, none of the above. So what is the right answer here? Just give your answer. Yes, may set aside the bond. Coming to the next question, when the consent is caused by misrepresentation, the contract under section 19 is valid, void, voidable, or illegal. So which is the correct answer? Just give your answer to the comment box. I am waiting for your response here. Just tell me. So whether the contract would be valid, void, voidable, illegal, what would be the consequence to the contract? Yes, it is going to be voidable. When the consent is caused by undue influence, the contract under section 19A is whether it would be valid, void, voidable, illegal. So just give your answer here. What would be the effect? What kind of effect would take place in case if the consent has been obtained by the undue influence? So just give your answer. Waiting for your response here. Yes, again it is going to be voidable here. So this is how you can find that the in case of undue influence happened, the contract is going to be voidable. Coming to the next question, where both the parties are under mistake as to matter of fact, the contract under section 20 is voidable, void, valid, or illegal. So give your answer here. What will happen, whether it would be voidable, void, valid, illegal? Just give your answer here. Both party A and B, both party are under a mistake of fact. Yes, in that case it is going to be void. Moving to the next question, where one of the parties is under a mistake as to matter of fact, the contract is whether it would be valid, void, voidable, illegal. So just give your answer here. Only one party is having mistake of fact. So in that case it is going to be a valid one. Considerations and objects are unlawful where it is forbidden by law or defeat the provision of any law, which is fraudulent, which is immoral, against the public policy, or all of the above. So if you just go to the options, you will find that all the options are correct, that in all these cases the contract is going to be unlawful, or consideration is going to be unlawful. So the right answer is here, that is D. Moving to the next question, if only a part of consideration or object is unlawful, the contract under section 24 shall be whether valid, voidable, void, illegal. So in case of a part of consideration is unlawful, what will happen to this one? So in this case, the entire, as per section 24, the entire contract is going to be void here. A contract without consideration under section 25 is whether it would be valid, voidable. So in a case a contract happens but it is without the consideration, what will happen? Moving to the next options here. Option C, void, illegal. Yes, in that case it is going to be void. In case of the contract is without any consideration, it is going to be void. Moving to the next question, consideration should be something in return or promise which both the law and parties regard as having some value. Only law regards having some value, only the parties regard some value, only adequate value necessary. So what would be the right answer here? Just give your answer here. Consideration should be something in return or promise both the law and parties regard as having some value. Only law regards having some value, only the parties regard some value, only adequate value necessary. So just give your answer here. So yes, it is both the law and parties regard as having some value. Moving to the next question, if the proposer prescribes the mode and manner of the acceptance, so whether the acceptance should be accepted in any manner or mode, should be in the manner and mode of prescribed, can be in any reasonable mode and manner, or all of the above. So just give your answer. Yes, it should be in the manner and mode as prescribed by the proposer. Going to the next question, parties are not competent to contract if any of them is minor, insane, declared unqualified, or all of the above. So what you find here, my dear friends, for the competency to contract, all these factors are important. So that means all of the above is correct. Consent is free under section 14 if not caused by coercion, fraud, misrepresentation, mistake subject to the provision of section 20, 21, 22, or all of the above. So in all these cases, the consent would be considered as a free under section 14 in case if it is not happening as per this condition. So therefore, all of the above is correct. So as per section 13 of the Contract Act, what is the definition of the consent? Consent under section 13 means agreeing on the same thing in the same sense, agreeing on the same thing at the same time, agreeing on the same thing at different times, agreeing on different things at different times. So what is the right answer? Give your answer. This was a question which was already has been asked in the UP PCSJ and also in some other states also. Yes, it is in the same thing in the same sense. Moving to the next question, a contract which is valid initially, however, ceases to be enforceable. Subsequently, the contract remains valid, becomes voidable when it ceases to be enforceable, becomes void when it ceases to be enforceable, or becomes void since inception. So what would be the right answer? Just give your answer to the comment box. A contract which is valid initially, however, ceases to be enforceable later on, whether in that case the contract would become a void when it ceases to enforceable, or it would be voidable. So the answer is here, this C. That means becomes void when it is ceases to be enforceable. Moving to the next questions, agreements the meaning of which is not certain or not capable of being made certain under section 29 is. So agreement the meaning of which is not certain or not capable of being made certain under section 29 is void, voidable, illegal, or valid. So what would be the right answer? Just give your answer here. It is going to be void one. An agreement in the state of trade under section 27 is whether an agreement which is in the state to trade is valid, voidable, void, unenforceable. So just give your answer very quickly. It is based on section 27. Very important question. Yes, it is going to be void. An agreement in the state of trade is valid under section 27 if it relates to sale of goodwill, mutual adjustment, business contingency, none of the above. So which is the right answer? Just give an answer. It is an exception to the section 27. Yes, in case of sale of goodwill, it would be not as a part of the restraint of trade. Okay. Moving to the next question, an agreement not to pursue any legal remedy to enforce the rights under section 28 is whether it would be valid, voidable, void, unenforceable. Give your answer very quickly to the chat box. I know you all know the answer. As per section 28, if you make any kind of agreement and it is in order to not to take any kind of legal remedy, you are making an agreement to A or B that you will not take your legal remedy, whether that kind of the agreement is enforceable under section 28. So it is going to be void here. So that is C. An agreement not to pursue legal remedies but to refer the dispute to the arbitrator under section 28 is. Now here you can see that you are saying that don't get the legal remedy, but you can refer to the arbitrator under section 28 through the agreement. So whether it is possible that you can have, yes, it is valid because you are not putting any kind of restriction absolutely on the legal remedies. Moving to the next question, an agreement to refer the dispute to the arbitrator is valid in respect of disputes already arisen or in respect of dispute which may arise in future, both A and B, neither A or nor B. So just give your answer here. So it may happen, you can in respect of this one, you can find that in respect of dispute which may arise in future also, it may also in the already arisen. So therefore this one is a correct answer, both A and B. An agreement by way of wager under section 30 is whether it is void, voidable, valid, unenforceable. This was a question which was already asked in the 2006 of the UP PCSJ. So just let me know what is the which section, what kind of the no effect would be happen on the wagering agreement. So just give your answer here. Waiting for your response. Yes, it is going to be void. An agreement in connection with the horse racing under section 30 is whether it would be unlawful, void, voidable, valid. So which is the right answer about the horse racing? So this is an exception and therefore it is a valid one. Moving to the next question, an agreement in restraint of marriage under section 26. So if you are making an agreement and that is restricting that someone can't do marriage, they can't do any kind of marriage. So what will happen about those agreements? So let's see the options here. Whether it would be void, voidable, valid, unenforceable. So just give your answer here. Waiting for your response. Give your answer to the comment box. I am looking for your answer here. Whether in that case it can be possible. Yes, it is going to be void here. So if only a part of the consideration, moving to the next question, if only a part of the consideration or object is unlawful, the contract under section 24 shall be valid to the extent the same are lawful, void to the extent the same are unlawful, void as a whole, valid as a whole. So what is the right answer here? So just give your answer here. Only a part of consideration or the object is unlawful. So what would be the effect on the contract under section 24 of this one? Okay, so just give your answer here. Looking for your answers. So in that case, the entire contract which is here, then it is going to be void. Okay, an agreement shall be void on account of mistake of fact by one party, mistake of fact by both the parties, mistake of foreign law, both A and B. So in which case the agreement would be void here? So just give your answer here. Yes, in case if both the parties they are having mistake of fact, then in that case it would be the void. Otherwise, in case of only one party is having a mistake of fact, then it would not be a void contract agreement. Okay, moving to the next question, question number 61. Coercion which vitiates free consent under section 15 is committing or threatening to commit any act which is forbidden by law, committing or threatening to commit any act which is forbidden by Indian Penal Code, unlawful detaining or threatening to detain any property with an intention to causing any person to enter into an agreement, or D, all of the above. So which is the right answer? So what you find that in all these cases under section 15 you can do this, you can do the coercion through these actions. So therefore all of the above is correct. What is correct of standard form of contract? So just give your answer here with these options. I am looking for your answers here. It is a valid contract. One party has no choice but to accept and sign the contract. Both A and B, the consent is not a free consent. So which is the right answer here? Just give your answer here. So standard form of contract is a valid contract. Okay, so even though you don't have any choice, but it would be a valid contract. Okay, now moving to the next question. Law of contract primarily specifies the circumstances in which promises are binding on the parties to the contract, or the law of contract primarily lays down certain norms by which the parties are bound, or third option lays down the circumstances under which a promise may be made, and the last option, that is all of the above. So just let me know which is the right answer here, my dear friends. Here, so law of contract primarily specifies circumstances in which promises are binding on the parties to the contract. So this is the right answer here. Moving to the next question, question number 64 here. Misrepresentation under section 18 means a positive assertion in a manner not warranted by the information of the person making it not true, but he believes it to be true. Moving to the next, any breach of duty which gains an advantage to the person committing it by misleading another to his prejudice. Next options which are here, that is the C, causing a party to make an agreement to make a mistake as to subject matter of contract, and D, all of the above. So if you just go to section 18 of the misrepresentation, you will find that all these elements which we have discussed here, which are given in the options here, they are a part of the misrepresentation, and therefore all of the above is correct here. Moving to the next question, question number 65. A person is deemed to be in a position to dominate the will of another by undue influence if the mental capacity is affected temporarily or permanent by reason of age, reason of illness, mental or bodily distress, all of the above. So when a person would be deemed that he has undue influence, in case if the opposite party is having mental capacity not well because of reason of age, reason of illness, mental or badly distressed. But in these cases, it would be a case of undue influence. So yes, my dear friends, if you go to this, you will find that here in this case, the mental or bodily distress is one of the reason, not the age only. Okay. So what you find that mental or bodily distress is one of the factor which you will find here. Then apart from this, you will find the reason of illness is here and reason of age here. So in all these cases, if any person is not able to take a decision and now the person is dominating the will of that person, it would be a case of the undue influence. Okay. Moving to the next question, question number 66. An agreement to remain unmarried is whether it is valid, voidable, void, unenforceable. So just give your answer here. For example, if A and does a kind of agreement that he will remain unmarried, whether that would be a valid one. So of course it is a restraint to marriage, so therefore it would be void. Moving to the next question, question number 67 here. A journal offer open for word at large can be accepted by sending a communication of acceptance, by complying with the conditions of offers, by tendering himself to comply the condition of offers, none of the above. If you just see this one, you will find that just simply by complying with the condition of offer, a person will be able to do a kind of acceptance. So therefore this is the option B is correct. The term consensus ad endum, what is the meaning of this? So the options which are given here: general consensus, reaching an agreement, meeting of minds upon the same thing in the same sense, and last option which is given, all of the above. So what you find that consensus ad endum means meeting of the minds upon the same thing in the same sense. So this is the right answer. C is the right answer here. Moving to the next question, which one of the following does not amount to fraud? Okay. Number 1, suggestion as a fact which is not true by one who does not believe it to be true. Active concealment of fact, a representation made without knowing it to be false, honestly believing it to be true. A promise made without any intention of performing it. So just give your answer immediately through the chat box, comment box. I am waiting for a response. So in these cases, when it would not amount to fraud. So what you do, my friends, you can see here, the option C is correct, because it says that a representation made without knowing it to be false, honestly believing it to be true. So this is how you can find that he was no have any idea that it is a false. So he was having very honest opinion. But while in other cases, he was not having the honest opinion, he was not having the good intention. Okay, moving to the next question, question number 70 here. Contract without consideration made in writing and registered and made on account of natural love and affection is. So when you are doing a kind of contract without consideration, and that is in writing and registered, and it was happened on the basis of natural love and affection, whether in that case the contract is void, voidable, valid, and unenforceable. My dear friends, in this kind of the contract there is no consideration. There is no consideration. So whether in that case it would be a valid contract or not. So this is an exception of a contract without the consideration, and therefore valid. It is going to be a valid, because it happens in case of father and child kind of the no relationship or any other relationship based on love and affection. Okay, moving to the next question, question number 71 here. Inadequacy of consideration does not make the contract. So let's see the options here. wired, wireable, unenforceable, neither wired nor wireable. So just give your answer here. Looking for your answer. It would not be wired nor wireable. So in that case, you can find here. Moving to the next question. Inadequacy of consideration is relevant in determining the question of fraud, misrepresentation, undue influence, free consent. So just see this one. So in case of there is a consideration is inadequate, whether what will happen to this one? Yes, so it would not be a case of fraud, misrepresentation. However, there may be some question about the free consent. Moving to the next question, agreement without consideration is valid when made out of love. When an agreement is made without consideration, it may be valid. The options which are here given here: when made out of love and affection due to near relationship, when made for compensate a person who has already done something voluntarily, when made to pay a time bar debt, all of the above. So which is the right answer? So in all these cases, you can do an agreement without the consideration. So all of the above is correct. A contract based on the happening or non-happening of future event under section 31 is called. So when you are doing a kind of contract and that is happening on doing or not to doing about a future event, whether it would be which kind of contract it would be, whether it would be contingent contract, wagering contract, a contract marked with uncertainty and hence wired, and none of the above. So my dear friend, just give your answer here. You all know the answer. I know this one. So I'm waiting for your response and giving few seconds to you. Yes, just give your answer. Yes, the answer is contingent contract. I know that you have well prepared and you are following all this question very carefully. Maybe some little bit no, because of blur and all these things, you could not read much well here in this question, but I am reading for all of you and you are getting, if you see, you will get the answers and questions very easily. Okay, if you read very carefully. A contingent contract to do or not to do anything on the happening of an uncertain future event under section 32, whether the options which is there, whether the contingent contract is never enforceable, becomes enforceable only on the happening of that event, enforceable since the time of making it, becomes enforceable in the immediate possibility of happening of that event. So which is the right answer? So whenever you will have a contingent contract, it would becomes enforceable only on the happening of that event because it depends upon the future event. Moving to the next question, question number 76. A contingent contract is wired. The options which are given here: never becomes wired when the event becomes impossible, or is wireable. So which is the right answer? Give your answer here. I am waiting for your response. So a contingent contract becomes wired when the event becomes impossible. Okay, a contingent contract based on an impossible event under section 36. When a contingent agreement is made, but it is based on the impossible event, whether it would be valid one, is going to wired, is wired till the impossibility is known, becomes wired on the knowledge of impossibility, or the fourth option, all of the above. So just give your answer here. So if the action is itself impossible, then it is going to be wired, okay, from its inception. Now moving to the next question, question number 78. What is true of misrepresentation? It is the same thing as a fraud. It renders the contract voidable, or the fourth option, it may be due to information innocence, or both B and C. So what you find that which is the right answer here? Just give your answer here. So in that case, it is both and C, because you don't have answer to this. Two person having the capacity to enter under section 11, if both are major, if both are not of unsound mind, if not be determined, not declare unqualified as per the law, or all are the correct. So here, if you fulfill all these provisions ground, then you are all are the correct. Okay, a contract with minor is voidable at the instance of the minor, voidable at the instance of other party, wired, valid. So a contract with a minor, whether it would be wired at the instance of a minor or other party. So you know that Mohri Bibi versus Dharmodas case, where you will find that the contract with minor is wired from its inception. An agreement to do an act impossible in itself under section 56 is, so when A and B, they are making a kind of agreement and the action itself is impossible, whether that agreement under section 56 would be void, valid, voidable, unenforceable. So just give your answer. So because it is impossible itself, then it is going to be void here. A contingent contract based on the specified uncertain event happening within a fixed time under section 37. So when you are doing a kind of contingent contract and it is said that the uncertain event will happen within a fixed time under section 35, so whether in that case the contract would be remains valid even if the event does not happen within that fixed time, becomes void as expiration of that fixed time, become void if the happening of the event becomes impossible before the expiry of time fixed, or both, and C. So you can see, my dear friends, in both the option B and C, the action could not be happen on the expiration of the time, and the action happening itself becomes impossible. So in both the cases, it is going to be void. So therefore, the options which are given here, the D is the correct here. So moving to the next one. A contingent contract based on the specified uncertain events not happening within a fixed time under section 37 can be enforced if the event does not happen within that time fixed, can be enforced if before expiry of time fixed it becomes uncertain that such an event shall not happen, cannot be enforced at all, being void, both A and B. So just give your answer here. So what you can find that the A and B both are correct here. A promiser can perform the promise himself, the promise through his representatives competent to perform, the promise through his representative irrespective of the competency of that representative, and both A and B. So a promiser can perform his action by whom? So what you can find that in this case, he can perform by his representation as well, or he can the promise through his representative irrespective of competency, that is also required here. So that can be also done here. So what you find that in this case the D is correct, because by both by A and B here, yes, here by A and B he can do. So this is not the right answer. So A and B. So promiser can perform his function by himself or through the representative as well. So moving to the next question. A promisee can accept the performance. A promisee can accept the performance. The options which are given here: A, from the promiser himself; B, from the representative of the promiser competent to perform; C, from a third person; all of the above. So what you find that in this case all of the above is the correct answer. Okay, the performance can be taken from the promiser competent to perform by representative as well. So this is how you can find here. In case of joint promises, generally the performance must be by whom? So when there are two promisee, in that case performance must be done by whom? The options which are given here: all the promises jointly, any one of them individually, one not authorized to perform, none of the above. So which is the right answer? All the promises jointly here. In case of joint promise, it would be all the promises jointly. In case of joint promise, generally a promise can compel. In a case of joint promise, generally a promisee can compel all the joint promisers to perform, any of them to perform, some of them to perform, all of them, all of the above. So what you find that in this case it is about the promisee. So promisee can do all these things by any one of these way. So all of the above is correct. Generally the joint promisers can compel each other to contribute equally, not to compel each other to contribute equally, cannot compel each other to contribute, none of the above. So what you will find that in case of joint promisers, whether he can compel each contributor to do equally or not to do equally. So what would be the right answer here? So he can compel each other to contribute equally. Now moving to the next question. Where one of the joint promisers make a default in contribution of performance, the other joint promisers have no right against the defaulter, have to bear the loss in equal share, not supposed to bear the loss, the contract becomes void to the extent. So I am repeating question again here. Where one of the joint promisor makes a default in contribution of performance. So what is the right option here? Just give your answer here, waiting for yes. So have to bear the loss in equal share, okay, in case of default. In case of default by joint promisors, the promisee can sue any one of them for the entire promise, can sue one of them to extent of his share or in the joint promisee. Both A and B and D cannot sue any single promisee. So which is the right answer? Give your answer here. Can sue any one of them for the entire promise. In case of death of a joint promisors, the promisee can enforce a contract against the survivors of the said joint promisors along with the joint promisors who are alive, cannot enforce a contract against the survivors of the said joint promisors. Both A and B cannot enforce a contract against any one of them. So which is the right answer? Yes, he can enforce a contract against the survivors of the said joint promisors along with the joint promisors who are alive. Moving to the next question, question number 92. In a contract not specifying the time for performance, the promisor can perform the contract. Where time has not been given, in that case, what would the timing here? Whether options which are given here, within any time of howsoever long it may be, within the shortest time, within a reasonable time, and none of the above. So my dear friends, you all know that when there is no timing, it must be performed within a reasonable time here. So therefore this option is the correct here. Okay. What is a reasonable time for a performance of a contract? So whether it is a question of fact, question of law, is a mixed question of fact or law, is a question of prudence. So just give your answer here, waiting for your response here. So it is a question of a fact. A contract not specifying the place of performance. In that case, performance, a contract not specifying the place of performance. So where the performance should be performed? Performed at any place to knowledge of the promisee. The promisor has to apply to the promisee for appointment of place of performance and perform in the promisee at that place. The promisor need not seek any instruction from the promisee as to the place of performance. The fourth option, the promisor can perform the promise at a place other than the place appointed by the promisee. So where he will perform? Just give your answer here, waiting for a response here. Yes, the promisor has to apply to the promisee for appointment of a place and appointment of place of performance and perform the promise at that place. Moving to the next question. In case the promisee prescribe the manner and time of performance of promise. So in case the promisee prescribe the manner and time of performance of promise, the options which are given here, the performance must be in the manner and at the time prescribed. The performance can be in a different manner but at the time prescribed. The performance can be in the manner prescribed but at any time at a time beyond the time prescribed. The performance need not be in the manner and time prescribed. So my dear friends, the option which is here, that is the A, correct. He has to perform in the manner and the time has been given. If the time of performance of contract is the essence of contract and the promisor fails to perform the contract by the specified time, then in that case what will happen? The contract becomes void, the contract remains valid, the contract becomes voidable at the instance of the promisee, the contract becomes enforceable. So just give your answer through comment and chat box. I am waiting for a response here, my dear friends. So just give your answers here. What will happen in that case? Just give your answer here. I am waiting for a response. Yes, the contract becomes voidable at the instance of the promisee. The next question, question number 97. If the time is not the essence of contract, the failure to perform the contract by the specified time makes the contract. So where there is not essence of the time, but of the contract, the failure to perform the contract by specified time makes the contract voidable at the instance of promisee, remains valid, but the promisee can claim compensation for the loss suffered by him by such failure. So my dear friend, this is the right option. Remains valid, but the promisee can claim compensation for the loss suffered by him. So in case there is no time has been given and the performance was not performed in a proper and reasonable time, then he can, the contract would be valid, but he can compensate he can sue and he can get the compensation for the loss suffered. Moving to the question number 98 here. In a contract for sale of immovable property, the presumption is that the time is the essence of the contract, not the essence of the contract, the essence of the contract, but failure does not make the contract voidable, not the essence of the contract, but makes the contract voidable at the instance of the other party. So in contract for sale of immovable property, the presumption is that the time is. So just give your answer here. What will happen? The answer is not the essence of the contract here. Okay. Moving to the next question. Reciprocal promise provide for doing certain things which are legal and certain others which are illegal under section 57. The entire set of promise is void. The first set is voidable, but the second set is void. The first set is valid, but the second set is void. The entire set of promise is valid. So what would be the answer here? So in this case, the first part, which is a valid one, then in that case it would be valid. But the second part, which is illegal, then in that case it would be void. So the option C is correct here. The last question of this one, which we are going to take here, the question number 100. A contract performance of which becomes impossible or unlawful becomes void when the performance becomes unlawful or impossible. Void, voidable when the performance becomes impossible. Neither becomes void nor voidable. So a contract performance of which becomes impossible और अनलॉफुल, व्हाट विल हैपन टू दैट कॉन्ट्रैक्ट. अगर कोई कॉन्ट्रैक्ट है जो परफॉर्मेंस के लिए है, वो इम्पॉसिबल हो जाता है वो परफॉर्मेंस, या अनलॉफुल हो जाता है वो परफॉर्मेंस, तो क्या होगा उस कॉन्ट्रैक्ट के साथ. सो जस्ट गिव योर आंसर हियर. यस, आई एम वेटिंग फॉर योर रिस्पॉन्स एंड दिस इज लास्ट क्वेश्चन ऑफ दिस 100 MCQ series of the contract here. Yes, the answer is void when the performance becomes unlawful or impossible. So with this, my dear friends, we are finishing 100 MCQs for contract, and all these questions which we had dealt here, they are very basics to the contract and they are based on the Indian Contract Act. I hope that you all have taken participation fully in this entire 100 MCQs of the Indian Contract Act, and that will be very much helpful for your revision of the UP Judiciary examination here. So with this, I am very much thankful to all of you for watching this video. Please make more comments so that we can improve good videos here. We can make good videos with more good ideas here. So with this note, I am very much thankful and thank you for watching this video. If you are first on my YouTube channel, please subscribe. And if you are liking this video, please do some comments and share with your friends so that they can also enjoy when they are traveling, when they are doing some other action. They can check all these videos on their mobile and then they can do a kind of revision. So with this note, thank you again to all of you.